Hi, everybody. Welcome to Trial Alchemy. And today I've got as my guest a very special guest, Jennifer Doan, who is the 2025 National President of the American Board of Trial Advocates. Today, we're recording this interview on May 15, 2025. And I wanted to do this interview with Jennifer to discuss the rule of law. And this year in 2025, we've got a lot of issues that have been coming up just in the course of everyday life with the rule of law. So let's start first, Jennifer, with this. And Jennifer, by the way, is an outstanding defense trial lawyer in the Texas area, and she defends corporations and does patent and other kinds of litigation. Is just exceptional. And I've got another interview with her that you're going to be able to see at another time. But let's talk today about this rule of law. So start off, we've got this system of government, Jennifer, created by our Constitution that was created in the 1780s, where we've got these three branches of government: executive branch, the Congress, and we've got the courts. And the whole system is set up with basically no one branch having complete power, with checks and balances, and with different branches having different duties and powers. And so when we talk about the rule of law, we're going to be talking mostly today about courts and about judges and lawyers. But why don't you start off? Let's start off with just you explaining a understandable definition of the rule of law. So how would you describe that to folks?
Sure. And Monty, thank you so much for having me today. I'm honored always to be on your podcast. I'm always happy to talk about anything you want to talk about, but especially with respect to the rule of law. You mentioned that our system is set up with three different branches. We have the executive branch, which is Article 1. We have the legislative branch, that's Congress, that's Article 2. And we have the judicial branch, which we refer to as the third branch. And like you said, they all have checks and balances. The executive branch leads us, the legislative branch, they make the laws, and the judicial branch checks over the executive branch and the legislative branch to make sure that how they're leading us and what the laws are do follow the rule of law. So in general, it's really important to understand what the rule of law is. It's really pretty easy, depending on what media you listen to, whether it's CNN or Fox or NPR or PBS or sort of anything in between that. And it's always good to listen to a smattering. Different reporters refer to it as a different thing, and it's on the news almost nightly here. But the rule of law is a system and a body of laws that are governing all of us. If they're created by the people, by all of us in a democratic process, we decide what the laws are. We decide they're going to govern all of us, and they govern all of us equally, whether from the poorest of our nation to the wealthiest of our nation to the most powerful of our nation. So, like a great example would be traffic, which I see outside, it's 5 o'clock. Traffic laws, traffic laws apply to everyone equally. We enact traffic laws all together. You elect someone to sit in your legislature or to go to Congress. They are your representative. They speak for you. They make the laws that we all agree that we're all beholden to. So that's what the rule of law is. It's a fairly easy concept.
Yeah, it is. And since very early in the country's history, with the case of Marbury versus Madison, the Supreme Court decided that it was the Supreme Court that had the power and the authority to decide whether laws passed by the Congress or the legislative branch were constitutional or appropriate. And it's got the power to make those kinds of decisions for executive actions and other things. So that's been a long time history. Now, why is that something that can be helpful and helpful in a democracy?
Well, it's great in a democracy because The United States Supreme Court is the supreme law of the land, and yet, we have the other branches that check the judicial branch as well. So, for example, the president of the United States on a federal judge, the president nominates for the federal judge, and they have to be confirmed by 2/3 of the Senate.
Right.
So you've got the two branches that are checking who is a federal judge, and then you've got that federal judge checking what the laws are as well. So, for example, if somewhere in the United States, and you'll remember the flag burning cases, whether
Yep.
I have a right to burn a flag, we might not like the fact that someone is burning our flag, but we all believe in free speech. We don't have to agree with what someone's saying, but we have to agree in a civil society they have the right to say what they're saying. And then, of course, there's always exceptions to those rules, like, speech inciting violence, speech, that's, if you're going into the pornography laws or something like that, there's always exceptions to laws. But, we see a lot of gun control laws now. We saw an opinion that came out of the Fifth Circuit a couple of years ago on the bump stock issues with respect to whether they were legal or not, and whether they said they were doing it or not. And so what you hear sometimes on the press, just like we were talking about earlier today on the case that was before the United States Supreme Court, sometimes you listen to the news and they say this was the rule of the Supreme Court, when in reality, that was not the rule of the Supreme Court. Like, for example, today, in the news this morning, it was all a flutter as to whether the Supreme Court was going to uphold the birthright citizenship. And actually, that's a constitutional issue in our United States Constitution. That was not the issue before the Supreme Court today. The issue was whether we could have one district court federal judge issue a nationwide injunction that would therefore contradict an executive order of the executive branch. And that was the issue the United States was Supreme Court was deciding. So it's really important as citizens that we understand what's happening with our laws, and that we take on our own duty to look at what it is, and to read these opinions that are coming out of the United States Supreme Court, or any court for that matter.
Right. Now, in the elected offices of the United States, we've got the president elected every 4 years. We've got senators who have 6-year terms. We have Congress people who are elected for every 2 years. And so they're responsible and have to be responsible to the voters, the constituents. But our constitutional founders decided that judges, when they were appointed in the federal system, need to have life terms. Why is that important when you're trying to have a rule of law in this kind of constitutional construct?
So I think it's imperative that our federal judges are appointed for life. And here is why. Um, it takes away all the politics. They don't have to run. They're not beholden to anybody. They don't take money from anybody. In fact, there's really strong laws against that, especially at the district court level and the Court of Appeals, so that they can make decisions that apply to everyone, and they're not having someone breathe down their neck saying, okay, well, then I'm going to run against you in the next election, or you might not be appointed on the next get-go, whatever comes up. So that's where you take the politics out. And I got to tell you, in today's media, in today's world, we hear a lot about that. Well, that's a Republican judge because they were appointed by George W. or H.W. or Trump, or that is a Democratic judge and they're, a Clinton appointee or an Obama appointee. And, you look at where the judges come down, they're coming down on what they think is fair and right and what's under the Constitution. And that's what we're all beholden to, and what the law of the land is. We might not agree with what the district court judge says or what the Court of Appeals even says, but the process, if we don't agree, is to appeal that judicial ruling. And if you have the facts and the law on your side, it goes to another body that looks to see and that grades the paper of the judge that made the original decision. And usually that all comes out just fine. I mean, if the judge was wrong or the facts didn't support what the judge is saying, then the Court of Appeals can reverse that. I mean, you practice law a long time. I've been practicing law more than 35 years now. I mean, I got to tell you, I mean, you take some cases up on appeal and the appellate court says, yes, you're right, your facts are with you, and then you get it reversed and sent back down for a new trial. Or sometimes the appellate court says, hey, look, here's a different angle of why you still lose, or why you are still right. So, but I don't feel like, and I don't see where the press is coming down on it is a Republican judges always support the Republican president, or the Democratic judges always support the Democratic president. I mean, look at our Chief Justice John Roberts on the Supreme Court. So he was appointed by a Bush appointee, and yet he is the reason that we have nationwide health care. Because when that came up during the Obama administration, remember, it was heavily attacked, and
Right.
it was a very close decision. The Democrats were saying at the time, hey, this is not a tax, but this is the law of the land. They've entered the law. Then the United States Supreme Court was looking at it. And here is a judge that's been appointed by a Republican who was a tie vote and said, look, it's a tax, but it's the law of the land, and we're going to go forward with it. And here's why it's constitutional, and told us how it was constitutional. So, there's lots of examples with judges that were at one point a political party or appointed by one political president of one political party, but that have their rulings don't really follow that necessarily party.
Yeah, well, let's talk about this, and maybe we can have something that may be helpful here.
Mm-hmm.
As a lawyer who's been practicing 45 years and been in this ocean of the law, just like you have, it's its own special environment. And I think what happens is people who are not lawyers or not judges look at it and assume it's just like everything else.
Mm-hmm.
And yet there's a difference. I think, in my experience, lawyers who practice law, no matter whether they're criminal or civil or plaintiff or defense or whatever they represent, and judges who act on the bench, whether they're federal or state, whether they're appointed by Democrats or Republicans, I think they're all trying to follow the law, and judges are trying to apply the law properly. And it's kind of a different worldview and a point of view. Is there any way that you've come up with to kind of give a good description of why that's helpful and why that's important? Because, I don't worry about somebody being a Republican judge or a Democrat judge. I think, from my experience, they are trying to figure out what the right answer is under the law, and they may come to different conclusions, but I don't think they're doing it because they're a Democrat or a Republican. So, what are your thoughts on that?
I completely agree with that. I mean, so the issues that we're taking up on appeal, and especially the issues that are heard by the United States Supreme Court, whether they're on the emergency docket or on the regular docket, these aren't clear cut issues. They're hairy issues that are important to be decided.
Right.
So we don't want them to be beholden by either party. But likewise, anytime you have two sides, and if it's not compromised and resolved, someone at the end of the day is going to win more than the other side. I can't say that there are certain opinions that we both, you both kind of get something, you both win. But usually there's a winner and there's a non-winner, right? We can call that a person that loses, but it's a non-winner. And so inevitably it's easy to have these sound bites to say, oh, the judge was horrible, the judge was wrong, the judge yada yada yada, when in reality, usually there's a well thought out opinion as to why the judge went a certain way, and it usually considers other factors that you had raised and why they either didn't apply, or you did win on that factor, but this other factor trumps more and they're following the law. And this is why it's so important. We have really a lot of clients out there that are trying to resolve their differences, and most cases are resolved before they get to court.
Right.
So we want to be able to tell our client, hey, I totally understand where you're coming from. Unfortunately, that's not the law. So if we want to change the law, we know we're having an uphill battle here, and it's got to be colorable as about why we want to change the law, and other maybe district courts or other analogous opinions that can support that change in the law. But it's important we give good advice to our clients so they know where the law is. And so it's super important that the judges are following what they call balls and strikes and how they see the best. I've yet to come across a federal judge where I feel like they just did things willy-nilly against the law ever. They really want to get it right. It's
Yeah,
important they get it right.
I think they do. So, and you've alluded to this already, but to go back to the legal process, so if there is a dispute or a problem, the general rule is somebody will file a lawsuit, and let's assume it's in the federal court, and it will go to the appropriate federal district court. And then the
Mhm.
process typically is you go all the way through that process, and if you can't resolve it, you go to trial, either a judge trial or jury trial, depending upon what the issues are. And then there's a decision. And then if somebody doesn't like the decision from that trial, they have a right to appeal. That's the process we have built in.
Mhm.
And then they can go to the Court of Appeal if it's a federal case in their federal system. And that Court of Appeal will then make a decision. And if somebody doesn't like what that decision is, in most cases, they would have to ask the US Supreme Court, will you take this case up? And
Right.
we believe there's some question of law that needs to be answered, or some kind of dispute between the courts of appeal that needs to be resolved. And if the Supreme Court agrees, then they will accept the case, but they may not accept it because they may not choose to do so. But if they do accept it, you will now have a hearing there, and if the Supreme Court makes a decision, that's the final decision. If the Supreme Court doesn't take the Court of Appeal decision, the Court of Appeal decision is final. Now, that's our general process for going through cases. Now, one of the recent things that we've been seeing this year, and we've had some decisions by some courts, and there have been statements and accusations and things made against the district court judge, the trial court judge, saying, well, that was something along the lines of that was a terrible decision, and we need to try to impeach that judge and remove them from the bench because we don't like that decision. Isn't that something that can create some problems?
Well, it can, but I will say, I think this started out where there were two or three members of the House Representatives who are on the record of saying, did you realize that the federal judges are appointed for life? So if we don't like what they're saying, we need to impeach them. And they called for an impeach-a-thon, if you'll remember that. And those are clearly individuals. I don't even know their names. I know there were three of them who maybe not have read or well versed in the Constitution, which is a different issue because that goes back to civics 101. But we don't. So the instances where federal judges have been impeached, these are or removed from office. These are judges that have done heinous acts as an individual, not in while they've been a judge. But say, for example, I'm not going to give you a hearing unless you pay me personally. That was one example. Sexual harassment has been another extreme sexual harassment for years. That's been another example. And so that kind of person doesn't have the moral turpitude and the judicial temperament to serve what we require of a federal and demand of a federal
Right.
judge, which we should all citizens should demand that. But there are a lot of federal judges that just don't agree with one side or the other. I mean, someone's going to file, if you get dismissed before a judge or jury trial, a bench trial or jury trial, you can get dismissed on a motion to dismiss
Yep.
early in the case or through summary judgment. And if you lose that, uh, you know, everybody that's been practicing a long time has lost. And so there's nothing wrong with thinking, wow, that judge really missed that. How am I going to reframe my case better for the Court of Appeals or reframe it better for a motion for reconsideration so that the judge can get it? It is the process, as Chief Justice John Roberts just reminded us, I guess it was like 6 weeks ago now. The process is not to impeach, the process is to appeal. And we've had that process in place for more than 200 years now, and it has worked great.
Right.
So, but it is amazing the people that have not read the Constitution, who may be in power, either in the executive branch or in the legislative branch, who think that they should impeach versus appeal.
Right.
Yes.
And the whole rule of law is built upon this concept of judges making decisions based upon the law. And then if you think the trial judge got it wrong and made a mistake, you still have a way to try to deal with it. And
Right.
You're not stuck with that decision, but you have to persuade the next court at the Court of Appeal level, or maybe all the way up to the US Supreme Court. But I think that system has worked quite well over the more than 200 years that our country has been under the Constitution. So
It
seems,
has, and our appellate courts, like I am in a twin city, in Texarkana, and so there's a Texarkana, Texas, and Texarkana, Arkansas. The Texas side, in federal court, except for certain cases that are patent cases, et cetera, they go to the federal circuit in DC, but they would go to the Fifth Circuit Court of Appeals, and that's, Texas and Louisiana, Mississippi. And then the Eighth Circuit Court of Appeals, which is where Texarkana, Arkansas goes to, is some other states, right? So when you are a circuit court judge and an appellate judge, you are looking at what your circuit has held, and then what other circuits have held too. And we look at that as lawyers and advising clients. So we can say, hey, look, the Fifth Circuit hasn't spoken to this yet, but the Sixth Circuit went one way and the Eighth Circuit went a different way. So
right.
this is something that may be new law. And do we have the right facts to make the best
The
law
new law, right?
in this area? Yes, I will say, and bad facts that we have sometimes make bumpy law, not very good law.
Bad
So,
law. Yeah.
yeah,
Well,
yeah.
when we talk about the rule of law, we're going to be talking not only about judges and what judges do, but I think we also have to consider the role of the lawyers. So I thought it might be helpful to share this with you, and I'm sure you have a similar thing in your state. In the state of California, where I practice and have practiced, every lawyer is required to take an oath. And they say, I solemnly swear that I will support the Constitution of the United States and the Constitution of the State of California, and that I will faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. As an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. Now, one of the things that I think sets ABOTA apart is that it is an organization that protects the right of jury trials, but in selecting attorneys to become members, it requires two important things. Number one, it requires a determination that the lawyer in question has proven themselves to be an excellent lawyer in trials before judges and other advocates who were trying the cases against them. But it also requires something along the lines of honesty, civility, being, a person whose word is their bond. So tell tell us and tell me, as the president of our national ABOTA,
Mhm.
what are the important duties that lawyers are supposed to carry out in this concept, in this construct of the rule of law?
So I think it's easy to assume that a lawyer, in representing their client, you're supposed to be a zealous advocate for your client, but this client's paid you, so you're going to say whatever they want you to say. But our duties as lawyers, we are an officer of the court. And so when we stand before the judge is also an officer of the court. And it's important that the whole process works well. So we want to have really good lawyers on both sides representing the issue so that the judge or the jury, whoever the fact finder is in the case, can make the right decision. He hears or she hears or the jury hears all the facts presented by the best oral advocates that are there. And why is that important? Because if you have one side that's really good and loaded for bear, and the other side is not, it can lead to gotcha moments. Like, oh, you didn't file the response, so therefore I win. And that may not be what is right or should happen. So you see lawyers, I mean, we represent all kinds of, not just our firm, but all lawyers represent all kinds of cases in pro bono matters. And we see recently where Paul Clement, a fantastic oral advocate, has taken on to be on the defense team of the judge that was arrested while she was on the bench. And forget about whether she's right or wrong. That's not the issue at hand today. But he wanted to make sure that the issue of whether you can arrest a judge while they're sitting on the bench, that needs to be represented really well on both sides. And so we have good lawyers taking sides. We have it all the time. I mean, we get appointed in criminal cases to represent accused shoplifters or accused murderers. I mean, lawyers, your job is to do the very best job on your side within the bounds of being an officer of the court. And what does that mean? You're always candid with the court. You one way to lose face is start not being quite honest or being shifty or not answering the questions. If you don't know the answer, you could just say, I don't know that. I'll have to get back to you, or I don't have that document in front of me. If you really don't know it, the judge can see that. But if it's asking a question that you're being shifty on, just answer it the best way that you can. Like, no, I can see where that doesn't usually apply, but here's why we're different. And then you can make your argument, but always being honest with the court. And the reason that's important is because if both sides are represented well and are honest with the court, and the judge is trying to make the best decision, and the jury's trying to find the facts as best they're presented, then the process should work well the way that it's set up. I'm not saying the process is perfect, but I will tell you, after speaking all over the world and looking at all kinds of different processes, we have by far the best system in the entire world in the United States.
Yeah,
I can see why I can see why others outside the United States would love to have the demise of democracy through destabilizing our judicial system. I could totally see that because they know it is such a great system. And we are all citizens are part of it.
yep, we're all
Mhm.
part of that. Now, a great historic example of a lawyer who is asked to defend and represent some very, very unpopular people was after the Boston Massacre. John Adams, who was a very talented lawyer in Boston, was asked by the local magistrate. He wasn't volunteering for this, but some of the British soldiers, I think one of the officers, needed to be defended in the case over the killing of people in that shooting. And lo and behold, against very unpopular, defendant that he was representing, he was successful in defending that person and getting an acquittal. So that's pretty impressive lawyering. And lawyers just have a responsibility to do the best job they can, whether their client is liked or loathed. And it
Exactly.
really is important. Now, another thing that I think is important that most people don't understand, and I'm sure you've had this same experience, whether I was a young lawyer starting out or even now, 45 years later, when I talk with judges, the same thing is spoken about every time we talk about it. The most important thing a lawyer has is their reputation.
Hmm.
And if a judge is trying to decide a case and that lawyer has a reputation for stretching things, not being accurate, being evasive, not always being trustworthy, that's going to hurt that lawyer. And yet, if that lawyer has a reputation for honesty and accuracy and dependability, that makes a huge difference. Have you had that same experience?
Totally had that same experience. And I can't agree with you more. It is so important to maintain your reputation and to make sure it is maintained well. You can't control what other people say about you, but what you can control, and it's two ways. One is when you hear something that another lawyer has said or done, call the lawyer. Don't assume that that is true. I don't care who the information is coming from. The second is if you learn that someone is disparaging your reputation, especially if it's on, sometimes it's ignorance that they're just passing on information that they've heard. And a lot of times this happens when you're winning a lot of cases, then someone may be jealous, saying some things or whatever else. But to go to the lawyer, and I would go one on one and I'd go see him. I wouldn't just call him on the phone. I sure would not send an email or text. Go talk to him and say, hey, you
Right.
know, I would I would want you to come to me and I'm coming to you. This is what I've heard and I want to make sure we set the record straight because we all need each other in the system. So lawyers bashing lawyers is a really, really tough thing to go down. It
Yeah.
is.
Well, now, in terms of the role of lawyers that we've been talking about, in some of the recent events that have been happening this year, and I'm not going to get too deep in the weeds of details, but the impression I've gotten from some of the things I've read, reading about some court hearings and some of the conduct of some of the lawyers, I've gotten the impression that sometimes some of these lawyers, and they seem to be representing the administration, Department of Justice lawyers, um, I've gotten the impression that they sometimes haven't answered questions the judge is asking or haven't accurately answered them, or sometimes I even get the impression maybe they're stonewalling. I mean, if those things are going on with the lawyer, I've got a problem with that. Do you think that's acceptable conduct if that's what's really happening? Because I can't tell you lots of
Yeah, if that's what that should not happen in the right process. And
yeah.
I don't know what the subject matter. I think I know, and it doesn't really matter what subject matter it is. It could be, something dealing with a real estate contract or
Yep.
a suit between two states or whatever else. It could be a criminal matter, whatever. Um, but as a lawyer at the top of your game, and what we expect of with respect to ABOTA is you answer the judge's question to the best of your ability. And if you don't know the answer, it's okay to say, I don't know the answer to that. I need to get back to you. What's not really okay is the judge asks question A and you're over here answering question, making it's not a media statement. You're over here selling your media statement to the judge. All I want to know is my question over here. That hurts your client when
Yeah.
you do that because it's frustrating to the judge. You can, I mean, usually when the judge is not needling, but really pinpointing want an answer from the lawyer and the lawyer doesn't answer, the lawyer feels like the answer is bad for the client. And so it's better to say, you are right on what the law is, but here's why it doesn't apply in this circumstance, ABC. But tell him you're right, but this is why it doesn't apply here. And if the law is against you, it's important that you acknowledge that with the judge. I mean, that's the only way that the laws go different ways in different circumstances. If the judge can say, okay, well, in this circumstance with these facts, an exception needed to be made. And so that's the argument you're trying to make, not what the basic law is. You
Right.
should always answer the question directly to the best of your ability.
Now, once again, that's because you're an officer of the court.
You're an officer of the court. Your role is not to have a gotcha moment. It's not to win if that shouldn't be where the law is. Your role as the lawyer is to make the best argument within the bounds of the law for your client and let the judge make the call.
Right. Now, under the rule of law and under our Constitution, the courts have the power, as the case law has evolved, to decide what's constitutional and what's not. But, an interesting thing is the courts don't have any police force to enforce their orders or any other um, group to try to enforce things. And so the whole system is built upon the idea that when the court speaks and it's a final decision, that order or decision will be followed. Now, that's pretty important in our system. And I think there's some issues that are coming up these days about whether decisions will be followed. Now, why is it important that whoever doesn't like the decision, but if a decision goes against them, they need to follow that decision?
Like we said at the very beginning, the rule of law are laws that are made by all of us in a democratic process for all of us. And so it's very important. We are not a dictatorship, and we are not a parliamentary process where you have like a coalition government, someone's elected and then everything goes that particular person's way. We elect, like you said, we elect the House every other year. So the House may change. It's really important that all three branches do their job. The job of enacting laws is not through executive orders. They're like band-aids. They're supposed to be
Right.
if there's not some other law. So it's important that the legislative branch does their job in setting laws. Very important. And I think that's where we see now there is, because we have sort of a open, maybe void with respect to the, like we have, that we haven't had in the past. We've got the executive branch trying to tee it up against the judicial branch. And it's important that we all see in the United States, all of us as citizens, including those that we elect to serve in Congress, so that laws can be made to ensure that the checks and balances remain.
Well, one thing when we're talking about the rule of law that we haven't mentioned, but I think I should, is judges, when they're appointed, take an oath to
They do.
protect and preserve the Constitution.
They do.
Legislatures, senators, congresspeople, they give an oath to do the same. And so does the president and everybody who's sworn into office. So the one thing that I think gets missed so often by the current media is every one of our people who are in government positions, whether it's the president or somebody who works in a department in the executive branch, or somebody who's a senator or a congressperson, or somebody who works for them, or judges, their highest oath is to the Constitution of the United States.
It
And
is. I mean, they take an oath before the Supreme Creator to follow the Constitution of the United States. Now, we assume that they've read the Constitution, and we do assume that they understand what it says. And that's, obviously the Constitution can be debated on certain issues. That's why we have great, if it was clear cut, it only said A, B, and C, we wouldn't be talking about it today, right? So I think it's really important. It's also really important that when you've got this battle between the executive branch and the judicial branch, Um, you know, the judicial officers, they have lots of law clerks and lots of help, really smart people that work for federal judges.
Right.
The same thing with respect to our executive branch.
Sure.
So I would assume that when the executive branch knows that they're pushing the envelope, for example, in the executive orders that were lodged to the different law firms, and I'm assuming we're going to talk about that here in a second.
Yeah.
But when you know you're pushing the envelope, that someone is advising the president before he signs that executive order, hey, this may be way over the line. We might not win this one. I'm assuming that if not, then the executive branch needs to make sure that you've got people. I mean, you don't want a bunch of yes men and women. You want people that can advise well on both sides.
Right. And you would hope, and I certainly do hope, that in the executive branch currently that there are people saying those kinds of things to the president, saying, you may want to do this. Here's risks of this. It may not work. It may be held unenforceable, but it's hard to know if that's going on.
I don't think we'll ever really know if that's going on. I do hope it's going on because we'd like to have the president of the United States represented and well advised at all times, whether it's a Republican or Democratic president, doesn't really
Yeah.
matter. But with respect to the executive orders that came out against certain law firms that said
Yeah.
they could not
Let's
go
go
into,
there.
yeah, so they couldn't go into federal buildings. I mean, and said they couldn't go into federal buildings that would include like the post office. I mean, the federal post office. It would include not just federal courthouses. And then it also did, there's a question of whether they were enacted as retribution for representing certain enemies or what the executive office perceives to be certain enemies or things that they don't believe in or they don't causes they don't believe in, et cetera. And they didn't want them to represent certain clients. And like we
Right.
talked about earlier, we represent all kinds of clients because the whole process works best when everyone is well represented. So we don't decide, oh, you're saved, you're going to go to heaven, you're a good person, I'll represent you. It's sometimes you're court appointed to represent people that just need a great representation, and you do your very best to zealously represent them within the bounds of the law. Um, there's four law firms that took that on. One is the executive order against Perkins Coie, they're represented by Williams and Connolly. That issue has been decided now. It's a 100-page opinion by Judge Burl Howard. Very well written, easy to understand. The complaint that Williams and Connolly filed on behalf of Perkins Coie, really well written, very easy to understand. You don't have to be a lawyer to understand the complaint that was filed. And you don't have to be a lawyer to understand Judge Howell's opinion. So Judge Howell, some of the criticisms have been, well, she was appointed by a Democratic president. And she was. But the judges that have the other three cases, the case against Wilmer Hale, the case against Jenner, and the case against Sussman Godfrey, they're all appointed by Republican presidents. And I don't see those going any differently. They all issued temporary restraining orders saying the federal government and executive order was wrong and overreached. And I think that it doesn't matter, like I said earlier, it doesn't matter if you believe, obviously the majority of America believes that this executive branch was the best to be elected at the time because he was elected by majority of the citizens.
Right.
And people may believe that he has the best policies, economic policies. That's totally fine. But it's important as citizens that we're not sheep. We just don't follow whatever, regardless of whether it's Republican or Democratic president. We have independent minds. That's why we are the greatest country in the nation, because we all are part of the government. And so when the executive orders come down that are clearly wrong, that are clearly overstepped, it's important that we see that. And it's important that we acknowledge that.
Right. Well, now, something that lay people may not understand, and may be important to talk about, is when you have a new president like our current President Trump, and especially when he's been issuing so many executive orders, but all presidents issue executive orders, it's almost like the thought that a lot of people seem to have is, oh my goodness, he's just taken over everything. But what they don't seem to understand is, yes, he can issue orders, any president can. But the question is, will the order ultimately be upheld? Will it be found to be valid? Will it be found to be invalid? And that's a process under the rule of law that takes time. So, don't you think people are sometimes missing the point that, yes, the president can do all kinds of things by executive order, any president can, but that doesn't mean they will be successful at the end of the day.
I agree. It does not mean they'll be successful. It doesn't mean it's wise.
Yeah,
Mhm.
yeah.
I
Well,
mean,
in terms of, we've talked a little bit about law firms. Now, in this current era where there are all these different issues with the rule of law, what kinds of things is the national organization of ABOTA doing to help protect the rule of law in this current environment?
so we're doing a couple of different things. One is that, we want to educate the public and we want to educate the legal world on what the rule of law is, why it's important to uphold the rule of law, different examples for that. And so usually we have a rule of law committee. Usually about once a year, you'll issue sort of a statement that is a teaching statement on why we do what we do. So for the American Board of Trial Advocates, we stand for four basic tenets. One is the right to trial by jury under the Seventh Amendment, which is civil cases. The second is the independence of the judiciary and taking up for judges when they are unjustly criticized. The third is uphold the utmost level of professionalism, civility, integrity, and ethics. And the fourth is to uphold the rule of law. So usually we issue statements once a year, sort of on this. It is May the 15th, and we've issued three on the rule of law so far, just because we've had so many issues dealing with the rule of law. And it's not just ABOTA, it's members of ABOTA that issue statements in multiple publications teaching why it is so important to speak up now. And Monty, it's easy to say, "Oh, I speak up all the time. I talk back to my TV screen, whatever they're listening to." But if as lawyers, if we don't say at this point in time when the rule of law is really under attack or being pressured hard, and put a stake in the ground of where we stand, then just standing by and talking, it's so easy to do that. It's so easy to do nothing and just turn the TV off and say someone else will handle that. Well, that someone else is us. So ABOTA has issued a number of statements, not just on behalf of ABOTA, but also with other trial organizations, because we are big on collaborating with our other trial bar organizations. So we have the International Society of Barristers, the International Association of Trial Lawyers, the National Bar Association, and the National Board of Trial Advocacy. We issued a recent statement with respect to the rule of law as well. Maybe that came out about a month ago. It's also important to advocate for amicus briefs on the rule of law. So when Williams and Connolly filed their complaint representing Perkins Coie, usually we don't see a lot of amicus activity in the district court level. Usually it comes on the appellate court level.
Right.
And by amicus I mean it's a brief. You're not beholden to either side. This is just where the law should be and where we see. So they had over 26 briefs, 26 amicus briefs that were filed on behalf of Perkins Coie and why the executive order was wrong. One of them was signed by 500 different law firms. We had law professors, groups of law professors, legal organizations, et cetera. So I know the American Board of Trial Advocates already has a team together to prepare for the appeal of that case, should that case be appealed by the federal government. And we'll file an amicus brief on that as well. So I think it's important you bound together with other law firms. Why is that important in that particular case? Um, because the district court judge, that federal judge, needs to know other people, other citizens are watching what you do. We knew that executive order was stepping over the line. I would be highly surprised if our president was not also advised of that as well. I would be highly surprised if he was not advised of that. And yet, it's someone had to file a complaint to take that on. So you're telling the judge, look, we've got citizens in the United States that are watching this.
Right.
You're telling both sides, you have citizens in the United States that are watching this. They feel very strongly about this. And so that's why amicus briefs are so important. They do educate from different angles the court of what's going on and why the law should be what it is, and why this would be over the bounds of the law. But amicus briefs are so important. Industries file them. There's usually in the United States Supreme Court, there's almost always amicus briefs filed in those cases.
But you make an important point because typically you're going to see amicus briefs only at the Supreme Court level or the Court of Appeal level.
Right.
So I think it's quite profound that you have all these briefs that have been filed at the district court level.
I do. And they are easy reads. Some of them are 3 pages, and they talk about what the rule of law is and why this is over the bounds of the rule of law. We get what we can have citizens.
Well, that's great. And it's wonderful that you and ABOTA are engaging in all this activity. So let's expand this out. Because lawyers who may not be members of ABOTA will listen to this podcast, and I'm hoping to help them get enough experience and ability to become a member. But what can lawyers do in their daily lives or with their practice to try to help with these issues of rule of law in this year that we're in right now?
Well, so, we have sort of a dearth of civics education in the United States, probably for the last generation. You may have had a child that was in AP government who might have gotten in a class, but the vast majority of America is lacking in civics. That's why our Supreme Court not Chief Justice, but Supreme Court Justice Sandra Day O'Connor founded iCivics, which is the #1 civics program for educating K through 12 about what civics is, the separation of powers, why we have it, how our bodies of law are set up in the United States, how we're governed, et cetera, and just basics of what goes on here. The ABOTA Foundation also has a number of websites with pre-planned studies to get it's ready to go for a teacher to teach civics in their classes. And then we have other organizations that ABOTA has partnered with, like the Center for Strategic and International Studies, which has got a program for teaching professionals, those who are beyond K-12, in big companies, like some of these really large companies who employ thousands of employees, to teach them civics because they may not have gotten it in school, so that your news isn't coming from just social media and somebody that's just using a bully pulpit and pontificating, but actually by what the laws are and what they do say. And I got to tell you, I think it's really important that our everyday citizens can understand what the law is. I mean, that's why we elect people. It's so important. And so it's not a turn off to say, oh, I don't know what that means. That's using big words. It's important that we keep laws very clean. So and clear. So it's clear for everybody. But this is the time that we use to educate ourselves to speak up. I've said it a couple of different times now. Back 40 years ago, maybe, you had a file and one doctor, and that one doctor treated you for everything, and that doctor knew everything about your body. That is not the same. And they kept all your x-rays. Right. That's not the same anymore. Now, if you get an x-ray, it may be kept for a certain period of time, may be deleted. You may see a different doctor the next time. Maybe your insurance isn't covered by that doctor. So it's on us now to make sure we have good health care and to make sure we keep our own medical records so that we can communicate to the next doctor what's going on, especially if you're a mother with children. It's super important. Um, the same thing with the law. It's important to keep abreast of what is going on and not just to turn on the news and say, or to read it on social media and say, well, that must be what happened. When in reality, that might not be what happened. And that is why it's important to listen to multiple different news stations and not just get your news from one. I would think almost all news stations, if they're not afraid of the news, what they're saying, they should all recommend that you listen to multiple different ones.
Well, we've had a great, wide-ranging discussion here about the rule of law. I think it's about time for me to wrap it up, but I want to give you any last words that you'd like to say on this important topic. And thank you so much for spending some time and talking about this important topic with me today. Any last thoughts that you want to share?
I would just commend anyone that's listening that thank you for being the ambassador that you are. And part of that being the ambassador for what the law is staying abreast of what it is, staying abreast of these issues. I understand sometimes they're exhausting. They're exhausting to all of us, but this is the time to speak up and not to stand up and to speak up and not just stand by and let things happen.
Well, thank you, Jennifer, Madam President of the National
Thank you,
American
Mike.
Board of Trial Advocates. Thank you so much for talking with me today about this very vitally important topic.
Thank you, Monty. Have a great evening.